Good evening, this is John Milburn for LAWS12062. This is Alternative Dispute Resolution. We're very much into the business end now, week 11, and next week we have the take-home paper. So the take-home paper will be released, I'll release it on Thursday at 6:30 p.m. and all answers must be in by Friday, 11:45 p.m. I will speak later about the take-home paper format, but I'm sure you've seen the material as it appears on Moodle at this stage. Now, when you submit your work, I will run it through Turnitin program. As I do for all the assessment work, one advantage of the take-home paper from my perspective is that I can access the Turnitin program for plagiarism. Just a few words about that, because there are some misconceptions. Certainly, CQU uses the program. Many secondary institutions do as well, and we'll be quite upfront, it is to guard against plagiarism. It is a highly effective program from what I can see. It's very accurate. Now, when you submit your work, I'm sure that you see a Turnitin percentage. I know that from the feedback and questions that I've received over the years from different students. And Paris is the take-home paper next week. Yes, next week. The take-home paper, can anyone help me with that? While we're on that topic, I'll release it on Thursday, the 10th of October, which is a Thursday at 6:30 p.m. So that's next Thursday. And it's due Friday, the 11th of October at 11:45 p.m. So if you haven't yet booked out your Thursday evening or your Friday next week, that is Thursday the 10th of October the evening or Friday the 11th of October, or preferably both, then please do that now. So thank you. All right, so back to Turnitin. The idea of the Turnitin program is to provide you with an opportunity to ensure that your work is appropriately referenced and at the same time encourage original writing. If you refer to material and you reference it appropriately, there's really no problem at all. You may not get great marks for the absence of original writing, but your main concern is to ensure that you reference material that you've sourced elsewhere. Now, the Turnitin program will identify that work which is drawn directly from other material or paraphrased. So if you're adopting an idea, then you should ensure that that is referenced as well. So just because you see a high percentage score, that does not mean that you are going to be done, as it were, for plagiarism, far from it. And of course, the other thing is that if you have material that you've accessed elsewhere, such as legislation, and you used great chunks of that material or quotes from a case, then of course you'd expect a percentage high score, particularly for shorter assessments. So it doesn't test directly for plagiarism. What it does is it matches material against something else, properly referenced. There are no plagiarism issues. It may not be the best writing, so if you see a high score, whilst that may not of itself be a concern, you may wish to consider rewriting the piece so that it's more original work. Turnitin is a program that highlights the possibility of intentional plagiarism, but it might also assist you by picking up unintentional plagiarism, improper or lack of citation, or just coincidence work. So there's a few things that you might consider there. Gary asked a question, what would be a reasonable expected time to complete the paper? That depends very much on your level of preparation. If you're starting from scratch, you'll probably need many, many hours. But if, as I expect, most of you have done the work and you're well prepared, then I would hope that you could complete the task within 3 to 4 hours. Now, having said that, it replaces an invigilated examination, which has a 2-hour duration. So if you're really working super hard, then 2 hours, you may be able to do it. But realistically, I'd allow some more time. Other questions, hopefully we can download the paper before. Yeah, I'll see if I can download it as quickly as I can at 6:30 next week. All right, so are there any questions about the exam? I said I'd go through it later, and I'm going through it now, which is fine. So just to confirm, it's 60 marks, 2,000 words, no late submissions accepted. 2 questions. The first question, hypothetical scenario, and the second question is an essay style question. You may have noticed something that I include pretty much on all of my papers, and that is that when you're completing the task, please consider ethical issues, practice standards, statutory provisions, case law, regulation, rules, and practice directions. That's not meant as some sort of bizarre hint. It's not meant as a checklist necessarily. But the intention that I have in saying that is that I do want you to think broadly, and I want you to ensure that you think about all of the material that could apply. So I'm getting some requests for example scenarios. Correct me if I'm wrong, but I've included past papers to some degree on Moodle. Is that correct? If I haven't, I will be able to do so. So if you look at the assessment regime, you'll see some past papers and examples there. If anyone has Moodle up on their screen, it would be useful to have a look at that and let me know, but I'll make a note to check. So usually I put the past papers under the assessments tab on the landing page at Moodle, and that will be the very best opportunity for you to practice. So.
Oh yeah, they're there.
They're there? Okay. All right.
Past take-home briefing papers, there's like 3 of them.
Good, okay. So just to answer that question, if you want an example, that would be the best place to go. I don't return the final paper. I do provide general feedback to students, and the task requires you to complete the work as if it's an assignment. It's not, but as if it's an assignment, which means in a single Word document, properly referenced, footnote referencing AGL C4, and then uploaded in a single document, even though it's in 2 parts for the question. Please pay particular attention to the rubric, which is contained within the question, and you'll see that that's in the information guide now. So if you've got an idea of what it is that I'm after, look at the rubric first. Have a look at the way in which I assess the criteria, and you'll see what it is that I'm looking for that will give you that high distinction score that we're all after. All right, so have a look at the information guide, check the rubric, check the assessment criteria, and have a go at past exams is probably the best advice that I can give. All right, thank you. Now, I mentioned that you need to consider ethical standards, and in that regard, ADR has a blend of those ethical standards that relate to members of the profession, lawyers generally, or psychologists generally, or whatever profession it is that you happen to be in as part of your ADR practice. In other words, whilst this is part of a law degree, and we're looking at it from the perspective of lawyers practicing in ADR, the reality is that many ADR practitioners are from different professions. Some are ADR practitioners full stop, not necessarily annexed to different professions. So in the context of answering a question as part of a law degree around ADR, I'd expect you to have some input in relation to professional standards for lawyers, but also some input in relation to professional standards for ADR practitioners. And even more broadly than that, it might be ADR practitioners as mediators or as conciliators or as arbitrators primarily. It might be other forms of ADR practice, But those three would be the main areas where you'd need to consider providing input in terms of ethical material. So ADR as a separate profession, as it were, is something that's relatively new. We do have now specialist ADR practitioners, but during the 90s, up until the 90s, there was no particular governing body. It was just ad hoc arrangements, primarily annexed to your individual professional ethics and your individual professional body. So the Law Society or the Bar Association of Queensland, for example, for lawyers. But since the 90s, we've had ethical standards imposed through the different governing bodies that now regulate the ADR profession. And when we think about that, there are some critical questions, aren't there? In that we now have governing bodies, Mediation Standards Board, for example, but there's an ongoing debate, do we need the governing bodies? And to what extent do these governing bodies regulate the profession of ADR practitioners? One thing that you need to consider also, if you're looking at ADR and ethics, is a third strand, and the third strand relates to the general law. In other words, things like consumer law, torts law, contract law will also have a bearing on the issues that are around ethical matters. So then there's the question, to what extent do things like consumer laws, torts law and contract law apply to dispute resolution practitioners? You may want to consider whether there is a separate code of conduct for ADR practitioners, and if so, where you might find that. Now, does anyone, as part of their research, come across any bodies that may have a bearing, or documents that may have a bearing on issues around ethics and ethical practice in an ADR setting? So I'll let you have a chance to type. Has anyone come across anything? What do you think of? Where would you go to research issues around ethical matters and ADR practice? Any thoughts? Well, we've got one contribution. Thank you, Peter, the Law Society. I'd certainly be looking at the Law Society, Queensland Law Society, if you're in Queensland, or the Bar Association, or both. What about the Law Council of Australia? Has anyone done any research through the Law Council? That would be another one as well. All right, so as part of your preparation for next week's work, I would be mindful of identifying the sources of ethical regulation of ADR practice. Now then, there might be another thing for you to consider from a general view, and that is there a difference in the way in which ADR practitioners should be regulated, depending on whether they're working as facilitators or they're working in a more determinative function? In other words, those that are operating in a determinative space, such as arbitrators, should they be judged more by the practice of magistrates and judges and members of tribunals, rather than necessarily those that are working in the space of mediation, because they might be acting in a facilitative approach? Now, if we go the other end of the spectrum, if we have, as we have done, categorised negotiation as part of ADR practice, does that mean that all those lawyers and other people that are involved in negotiations are also covered by these ethical obligations? I'm very conscious of the fact that I'm not necessarily providing you with answers here, but I'm asking you to think about this in a more broad fashion, so that as you're doing your preparation, you think about, if I have a question that relates to this type of ADR practice, do I understand what the practice is all about? What does it mean? How does it operate from a practical perspective? And then we think about what are the regulatory constraints and obligations imposed on that type of ADR practitioner. So if we think about mediation, for example, we then have to consider what is the process, how does it happen? We did that in the first assessment. But now for the second assessment, the take-home paper, we have to go much more broadly, don't we? It's not just a matter of identifying this would be a good job for a mediator. We have to think about, well, what's going to be in this problem that John set for week 12? What if there's some ethical issues? You can't answer the ethical issues question until you first identify who is regulating the ethics and where do I look to find some of the ethical answers. Now, Gary raises the issue that they might overlap, and they certainly do. So, and it may be that the ethical requirements for ADR practitioners differ. Let's say case appraisers, that may differ if that person happens to be a case appraiser and a lawyer as well. Then there are some other practical issues in terms of indemnity insurance, etc. So if you're looking to advise someone in relation to something that's gone wrong for a mediation, for example, would you be considering whether that person is appropriately indemnity insured through indemnity insurance? And if so, how? So if, for example, a lawyer is undertaking mediation work, will you be claiming on the mediation, some sort of mediation insurance that's separate to the lawyer's practice insurance, or will it be tied in together? So, for example, you'd need to consider in the context of a barrister doing mediation work, what is the work of barristers? Does that include acting as a mediator? Does anyone have any thoughts? Is that part of barristers' work to be a mediator, or is it something separate? What do you think, Peter?
I think it'd be something separate, John. A barrister is an advocate, and therefore I think that mediation is a separate issue and should be insured as a separate issue.
Thank you for that perspective. Emma agrees and says separate. Gary says seek clarification from your insurance body. Well, I'll give you a hint. The answer to that one is it's a trick question because it depends on when you're looking at this. Up until 3 years ago, it was certainly a separate matter. But 3 years ago, the barrister's rule was changed to broaden the definition of what is barrister's work. So now mediation is part of barrister's work. So your answer is just correct, but depends on the timing. At the moment, no. So
Out of date.
Just slightly out of date, yes. So the reason I'm raising this is that if you're thinking about ethical issues, if you think about broader issues, liability issues, you've then got to think about indemnity insurance and what is the work of barristers, etc., for example. So at the moment, generally speaking, ADR practitioners are covered by indemnity insurance policies through their own profession, but there's a wider question, should ADR practitioners who are not linked otherwise to a professional body be forced to have their own indemnity insurance? And I think many of them do. So, but the question then is, well, to what extent? As I said, depends on what we define as ADR practice and what we don't. So there are a few grey areas here. And when it comes to ethical issues in ADR practice, I guess one of the practical perspectives that you might want to consider, this is potentially for the take-home paper, is ethical standard measured against what? So if, for example, we have someone involved in ADR practice and they happen to be doing some work in relation to early neutral evaluation, and we say, well, what they've done as part of their early neutral evaluation is not ethical, the question must be asked, not ethical against what standard? What is the appropriate benchmark that applies? This is where we need to change our thinking a bit, don't we? Because if we're talking about the ethics of a lawyer, as we've been doing throughout this whole law degree until this time, we go to the Legal Profession Act, we go to the Australian Solicitors Conduct Rules, we go to the Barristers Rules, don't we? And they're not codes, but they give us a good idea of what it is, and then we look at the common law to determine the ethical requirements. But it might be broader when we're talking about mediation practice. Now, Gary raises a question, how then does Section 53C come into it? And I must confess, Gary, you've got me there because I don't know Section 53C. Can you assist me? Now, I might know it when you tell me, but I just don't know it at the moment.
Well, we're talking about protection and liability insurance and indemnity and everything like that. But under Section 53C, it actually states a mediator or an arbitrator has, in mediating or arbitrating, anything referred to under Section 53A has the same protection and immunity as a judge in performing the functions.
Is this the Legal Profession Act?
No, Federal Court of Australia Act, 1976.
Oh, okay. Yes. Very good. All right. So from a federal sphere, the Federal Court of Australia Act. Yes.
Yep.
And we did talk about some of that last week, didn't we? So thank you for that. So if we follow Gary's lead, what we'll be doing over the next week, amongst all the other things we've got to do, is start to put together a little flowchart list, checklist, whatever it is that works for you, that will point you quickly to issues around ethics and liability. So thank you, Gary, for that. And thank you for letting us know about 53C. I'm sure we talked about it last week and I've forgotten since then. Sorry. The other place that you might want to consider is, I mentioned earlier, the Law Council of Australia. And the Law Council of Australia puts out some policies and guidelines that relate to ADR practice. They're referred to, I think, in the notes, maybe in the Moodle site, but do look up the Law Council of Australia and have ready to go reference to ADR policy and guidelines. So the Law Council of Australia provides some information about the process, and you'll see in the material that it's largely directed towards mediators and ADR practitioners on the one hand and participants on the other, or it may be more specifically lawyers that are acting for participants on the other. The key issues generally relate to fraud and misleading statements, and shortly we'll deal with a case on that. So when we're looking at it from the perspective of the mediator or the ADR practitioner and ethical requirements, we would say, well, of course, there's an obligation on the mediator not to be involved in fraud or misleading statements. What if, for example, and this is just a hypothetical example, a mediator says in an opening statement, look, anything that you tell me in private session remains confidential as between us, and I won't pass that on to the other side unless I have your specific approval to do so. What if, through incompetence or lack of care or some other reason, a mediator does actually quietly tell the other party in the private session something that was communicated to them by the other party in their private session? Would that be fraud? Would that be a misleading statement?
It's not
Or
fraud.
would it be just trying to help? Yes, Michael.
It's not fraud. It's just trying to think of the word for it. It's just not fraud. It's incompetence. It's not the word I'm looking for though. Yeah, it's not
The
fraud.
slip of the tongue. It's like getting caught up in the moment, bit of enthusiasm.
It could be liable for things. Yeah, negligence. Thank you, Peter.
Yep. So, and Emma says it's a breach of their duty. It's negligence. They're being negligent, says Peter and says Paris. So, reckless
Unintentional
perhaps.
misconduct?
Yes, Gary, could be intentional misconduct. So,
Unintentional.
or unintentional, could be. So it could be all of those things. But the question is, well, what do we do about it? And if you're mounting an argument, you might say, well, what is it? It's a breach of contract. It's a breach of their duty, says Emma, but which is good. But we have to have some clarity about breach of duty against what standard. Where do we find the standard? So tonight we're sort of broadening our horizon so that you've got an idea. Emma suggests NADRAC, always a good place to think of. NADRAC doesn't exist now, we know that, but it does provide some excellent terms of reference. So just on that point to digress, if we look at the part of the reading for this week, and I'll share the screen just so you're not looking at me the whole time. We have, hopefully this is coming up on your screen now, the NADRAC documentation from February 2011, maintaining and enhancing the integrity of ADR processes from principles to practice through people. And the NADRAC material provides some of the information that we're talking about now and what it is that is required for ethical practice. Conduct obligations, confidentiality, breach of that confidence, which goes to the example that we've just talked about now, confidentiality protection through contractual arrangements, and ADR practitioners' codes of conduct. And then there's some wider issues again, and that is to do with admissibility and inadmissibility. And as Gary mentioned earlier, the other issue is practitioner immunity. And to what extent is the ADR practitioner immune under common law or statute, contract, or other sources of immunity? So we'll all remember section 53C, thank you, Gary, in that context. But we need to do our research and be ready to go. So for the purpose of the take-home paper, I guess the message so far is don't just look at the question in isolation as a legal question, but always think about it in terms of ethical requirements as well. And then if we do that, we then have to consider where do we find these ethical requirements and how do we suggest that someone has breached the ethical requirements. Gary says section 53B applies also. Peter talks about the National Mediators Accreditation Standards. Yes. So the National Mediation Accreditation System Standards, thank you, Peter, do apply also, but perhaps only in the context of mediation, but very important. Paris says, can we use this if it applies in the exam? Yes, I'm sure Gary would be delighted. If you're talking about Gary's contribution, Gary would be delighted, I'm sure, for people to use that. So Peter's identified another potential source of information where we need to consider. That is practice standards as set up through the NMSAS. So we need to look at the National Mediator Accreditation System, the NMAS, and what it means to be bound by those practice standards. Has anyone looked at that website, those standards? Come across any conduct policies? All right, so that's some homework to do also. And when I talk about in the exam, I talk about practice standards and I talk about regulations, etc. This is what I'm really getting at, so that you're thinking more broadly and not just thinking about legislation and case law. So it is, question then is it permissible to ignore the practice standards? To what degree are they binding? What can you do about it if someone is, it's been established that a mediator or an ADR practitioner has not followed the practice standards? Apart from saying you've been very naughty, is there any other ramification to the practitioner? Peter also adds the Family Dispute Resolution Practitioner Standards and accreditation. Yes, so if there's a question that relates to family law, then you may need to consider that as well. So having some research, having some hyperlinks so that you can work, you know, and have the task next Thursday, Friday done as quickly as possible and painlessly as possible is a good way to go.
John, can
Now,
I ask a question?
yes, Emma?
Sorry. I know we dealt with this way back at the beginning, but it's been a very long term and my brain is mush. NADRAC's been dissolved. What has consumed that? Where has all of that stuff gone? Is it in legislation or where's it all gone?
That's an excellent question. And the answer is it hasn't. No, and the question is it hasn't actually been absorbed anywhere. A lot of the material has been extracted and used in various ways, but at the moment we refer to NADRAC as kind of this authority that existed for a period of time, and it set the benchmark. So it may be that some of the material that was established in NADRAC has filtered into individual practice standards or policies or guidelines or even legislation or case law, but there's no direct link from NADRAC to anything else now. I hope that answers your question, Emma.
Yeah, that's great. Thank you.
Thank you. And Gary says depends on the area of practice. I agree with that as well. So if you're looking to answer a question about ethics, then I would approach it something along these lines. I'd first consider whether the ADR practitioner concerned is part of a profession. And let's assume for a moment that that happens to be law. Then you'd ask yourself, well, are there any general guidelines that deal with issues around ethics to do with that ADR practitioner who happens also to be a lawyer? So you'd think about, in Queensland, the Legal Profession Act, you'd think about the Australian Solicitors Conduct Rules, and you'd think about the Barristers Rules. We've mentioned something in the Barristers Rules tonight. Beyond that, you'd think about case law, and so therefore the common law, and that may apply to lawyers, or it may go a little more broadly and talk about ADR practitioners. Then I would think about national standards, practice standards, and you'd then have to think about, well, what are the standards? Where do they apply? Well, that's probably in the context of someone wanting to be accredited, either as a family dispute resolution practitioner or as a nationally accredited mediator, for example. So what's the training? What's the assessment regime? And are there any ongoing practice standards? What are the guidelines? So we'd be looking at the Law Council of Australia, things of that nature. And then, of course, you've got to look at legislation more broadly, as Gary quite rightly pointed out, and you'd need to look at ethical obligations or immunities as they might apply under, say, the federal court legislation. Well, I hope that gives you some idea of what you might need to consider and where you might need to look in terms of ethical guidelines. So you're looking to establish a list now for yourself of things that relate to practice standards, codes of conduct, and you might even think about whether there's any system for addressing concerns and handling complaints of ADR practitioners. Can anyone for a moment think of any outside agencies that might deal with complaints of ADR practitioners or around ADR practitioners? Yes, Peter.
Administrative Appeals Tribunal.
Yes, the AAT might assist in that regard. Any other bodies, organisations that might deal with issues of complaints? All right, so, and it may depend on the industry. So for example, there are various ombudsmen, aren't there, that deal with different complaints to do with, I don't know, financial matters or insurance matters. So telecommunications. So if you're dealing with an ADR question that relates to a particular industry, then if you're really thinking broadly, you might think, well, should I take this matter to court, for example, to complain, which is what we tend to think about, or should I take it somewhere else? Then you might think about, well, are there standards, not necessarily in Australia, but somewhere else, to which I could refer that may have some influence, that may have some bearing on the question. So, for example, the American Arbitration Association has a code of ethics in relation to arbitrators. So I'm asking you to be really broad in your reading about this and think broadly. Now in the textbook, and in our reading material this week, we've got a couple of cases and they give you some idea of the extent to which ADR practitioners or people that are representing parties in an ADR practice might become involved. So there's Mullen's case, which dealt with the issue of a barrister who was not the ADR practitioner but was acting for a party in a mediation. Has anyone read Mullen's case? This is Legal Services Commissioner against Mullins, 2006 LPT 12. So the LPT was the Legal Practitioners Tribunal. That's now part of QCAT. So QCAT, which was created in 2009, was an amalgam of, I don't know how many tribunals were wrapped up that became QCAT. So now QCAT would deal with this sort of case. Right, so the barrister in that case of Mullins, which is Mullins, acted as legal representative for a party in a mediation. And just before the mediation, the barrister became aware that his client, who was a quadriplegic because of the accident, had cancer and therefore had a reduced life expectancy. Can anyone tell me why that might be relevant when it comes to the dollar figures?
Negotiating an ongoing settlement for
Yes.
life.
So why would life expectancy have any bearing on the ultimate dollar figure in a case like that?
It alters your compensation amount.
Yes, it alters the compensation amount, says Emma. I agree. But why? Time span, says Gary. Yes. So sad, but it's just the reality of life that if you're pursuing a personal injuries matter and you're doing so on the basis that a person has to sustain themselves for a length of time, that's an assumption that we make, which is something that can be overtaken or rebutted as a result of further evidence. So at the time of initiating the proceedings, there was no evidence that the plaintiff's life expectancy would be shortened other than by as a result of the accident. The insurers went into the mediation in the belief that there was nothing that would otherwise have a bearing on the life expectancy. So the barrister is in a difficult position and indicated that the barrister indicated to his client this information should be disclosed to the insurer. The client did not want that information disclosed. The barrister discussed the matter with senior counsel and took the view that if he didn't mislead the insurer, but didn't disclose it either, he would be complying with professional obligations. And Gary's right, Evidence Act, I think we dealt with this in evidence as well. Those of you that did evidence law with me might be aware of this. Now, the rules of the Queensland Bar Association, the barristers' rules, said this: a barrister must not knowingly make a false statement to an opponent in relation to a case, and a barrister must take all reasonable steps to correct any false information unknowingly made as soon as possible after the barrister becomes aware the statement was false. Now, in this case, of course, the insurance company did find out about it and made complaint to the Bar Association, the Legal Services Commission, and the Legal Services Commissioner prosecuted the barrister, arguing that the barrister was guilty of professional misconduct. In the mediation, even though the barrister had said to the client, we should disclose this, the fact is that the barrister did not disclose it because of the client's instructions. And the argument from the Legal Services Commissioner was, by failing to disclose that information, the barrister was in fact misleading the insurer by failing to disclose information about the reduced life expectancy. So what was the decision in that case? Did the Legal Services Tribunal, the Legal Professional Tribunal, agree with the Legal Services Commissioner? Was the barrister acting unethically by failing to disclose that information where the client had said, I don't want you to disclose that information? What are your thoughts? It's a tough one for the barrister, because the barrister's saying, I didn't intentionally mislead anyone, and I was told directly by my client not to give that information. Anyway, Justice Byrne, who was sitting on the tribunal, with others, came to the conclusion that the barrister was guilty of professional misconduct. So the case turned on an omission, and the initial material was correct, but it was after that and before the mediation, but only just before the mediation, that the client's prognosis changed. And because, in effect, the barrister failed to draw the other side's attention to the change, it was held in the interests of integrity and fairness that the barrister should have done that. Now, the barrister didn't receive any personal benefit from the failure to disclose, only got a headache as a result of it. And the tribunal ordered a public reprimand and imposed a personal fine of $20,000 on the barrister. So that wasn't a very lucrative case for the barrister. So a similar action was brought and again succeeded against an instructing solicitor who remained silent during a negotiation, and that was the case of Legal Services Commissioner against Garrett, which was 2009 LPT 12. So keep that in mind if you have a question in relation to ethical matters, and that's Mullen's case. When you're looking at these things, also consider the concept of good faith. And good faith can mean a few things in different circumstances. We talked about that, I think, last week. So look at good faith under the Family Law Act. It refers to genuine effort. Also think about NADRAC and the obligations that might be imposed as a result of those general overriding principles. You know, do parties have do they have a responsibility to take genuine steps? And does that mean also a responsibility to clarify disputes and correct information that might be wrong? If we rely on Mullen's and Garrett's cases as authority, then we would probably come to the conclusion that it must be something that is corrected. All right, any questions then on ethics? Have I just made a whole lot of work for you that you weren't counting on? But you need to know this stuff. Next week we have week 12, which is our review week. But what I will do is deal with some special issues that might arise in relation to ADR practice and the future of dispute resolution. And this week, I usually deal with ADR and criminal law procedures, restorative justice. I'll touch on that next week, but if you listened carefully enough during a session, I think 2 weeks ago, I quietly made the comment that you will not be examined this year on criminal law process and restorative practice, restorative justice. So next week's session on justice mediation, criminal law mediation will not be examinable, but we'll still deal with it. All right, so I might, as I promised, I'll have an early night tonight. Do we have any questions before we wrap up? All good? All right, thank you. All right, well, we'll close up for tonight. We'll see you next week. Make sure that you've got your diary booked out for late next week for your take-home paper. All the best. We'll see you then. Thank you.